Hi everyone, welcome to the O'Connor Elder Law Show. I'm your host, Melissa O'Connor. Today I wanted to talk to you about wills in the state of Florida and the importance of having them executed properly. I had a client that recently came to me to probate a will after the passing of their relative. One of the things that's unique about Florida is that the wills to be valid in the state of Florida require not only the person who is drafting the will, the testator, to sign the will verifying their wishes. It also needs to be executed before 2 witnesses and a notary to be valid. Other states may allow you to just write your wishes on a sheet of paper, sign it, put it in your drawer, and that might be acceptable in that jurisdiction. Those types of wills in law are called holographic wills. Holographic wills are not permissible in the state of Florida. Here we require 2 witnesses and a notary in support of the testator's wishes. So this client had presented me the will that was signed by their relative for probate. And when I noticed the will, I reviewed it and I noticed that the witnesses and the testator and the notary, they didn't all use the same date when they signed the will. There were conflicting dates. Well, this can be, something simple. You think, oh, somebody just didn't know what day of the week it was. They just were off by a day. Common, right? Well, this common error causes headaches when you seek to probate the will. What we ended up having to do is we had to locate the witnesses and the notary to be able to have them sign affidavits in support of the will to state, yes, I was there that day and we signed it, and the dates that don't match, it's just a scrivener's error. It's really not any indication that the will is fraudulent or that there's a problem with the will. And so locating these witnesses years later after the person has passed away could be problematic. Luckily for us, we were able to find them, and they were happy to come down to the courthouse because these affidavits, at least in the county that this case took place, had to be signed in front of the clerk of court in the downtown courthouse, and we were able to smoothly proceed with the probate of this will. So the reason why I even mention this and bring this forward today is because I wanted you to be aware of the importance of a will signing and the importance of dotting your I's and crossing your T's and being meticulous with details. Because if you're not meticulous with details, your family later on may find themselves in a predicament where they're having to do investigative Magnum PI type work to track down your witnesses so that way they could probate your will and actually effectuate your wishes. And so this is just really important when you are preparing your will. If you use any sort of online form and don't use an attorney to support you, that you are very cautious and make sure that you look at the dates and the signatures and that everything is in compliance with the self-proving will that's required in the state of Florida. Generally speaking, if you hire an attorney, they should be responsible for making sure that everybody signed it properly at the signing, so that way they won't run into these problems when they go to probate the will. I hope this information is helpful to you and you understand that in the state of Florida, wills need to be self-proving. They need to have 2 witnesses and a notary that sign all at the same time with the testator and use the same date, the correct date, to make sure that you have a smooth probate, if there is such a thing. If this content was helpful to you, I ask that you like and share with friends who may benefit from it. Thank you, and I look forward to seeing you again.